Hello everybody, my name is Kelly and welcome to the Potomac View. The Potomac View aims to interpret the most pressing issues and topics between the United States and China. Today we are delving into a special case where the integrity of the U.S. justice system is being called into question. Miles Guo, an active dissident of the Chinese Communist Party, has been faced with an overwhelming number of lawsuits brought against him by affiliates of the Communist Party, designed to distract him from his quest to expose the corruption of his home country, most of which targets his credibility and wealth. As one of the most wanted opposers of the Chinese Communist Party, Mr. Miles has no other choice but to file Chapter 11 for bankruptcy. In bankruptcy cases, a trustee is appointed to oversee the debtor's estate during the bankruptcy proceeding. The trustee is supposed to be an unbiased third party in all cases. However, in the case of Pacific Alliance Asia Opportunity Fund LP versus Mr. Guo, something odd has happened in the last couple of days. Let's begin with the U.S. Department of Justice Trustee Program, which oversees the administration of bankruptcy cases. Trustees are appointed and tasked with administrative, regulatory, litigating, and enforcement responsibilities according to the DOJ. First, Mr. Guo was originally assigned Joe Whitley as his trustee. Mr. Whitley is a trusted and well-known lawyer with no affiliation with Mr. Guo. In the words of the judge, Mr. Whitley signed an affidavit as a disinterested person and therefore appeared to meet the requirements of a trustee on June 30, 2022. But after only 5 days, the DOJ recalled this decision with no acceptable reasoning, only that someone from Mr. Whitley's firm was apparently connected to the case during a hearing on July 6th. The judge argued that the only 3 reasons why the trustee would change after signing an affidavit would be resignation, removal, or death, which the removal of Mr. Whitley did not fulfill. And on July 7th, Luke Despens was appointed as the new trustee for the case. Luke Despens is a partner in the corporate practice of Paul Hastings, where the law firm's partners have cooperated in past lawsuits and business acquisitions with the Pacific Alliance Group, PAG, representing a conflict of interest. Mr. Miles' case was brought against him by Pacific Alliance Asia, PAX, which is a direct partner with PAG, where John Lewis is the director of Pacific Alliance Group Asset Management Limited, acting as general partner of Pacific Alliance Asia Opportunity Fund. Paul Hastings LLP also represents PAG Real Estate, along with many related clients. As trustees are required to be impartial, this is another clear evidence of conflict of interest. This firm, along with its history of collaborating with PAG lawsuits, its partners can also be linked to the Chinese Communist Party members. For example, Jia Yan, a partner of Paul Hastings of the Shanghai and Beijing offices, studied under Hu Ningwang, a member of the CCP's Politburo Standing Committee, and holds a close relationship between them. Paul Hastings LLP also collaborated with local Chinese governments and Chinese banks, where there are numerous ties between Jingshang Bank and Harvest Fund, which are also points of conflict. And as of today, Mr. Despens is officially the trustee for this case. If all these connections were dismissed by the U.S. DOJ's trustee office, where did the integrity of the selection process go? Second, the process of judgment should be examined as well. Mr. Guo's case has been decided based on a partial summary judgment, where the judge rules on the case based only on the evidence provided by the plaintiff, and Miles was not allowed to challenge the material provided. Along with his lack of ability to challenge the evidence against him, he cannot escape the issue regarding a conflict of interest, which puts Mr. Miles in an unideal situation.
And I think this process doesn't make any sense. Either you appoint someone or you have a vote. And that's what the code sections require. That's what it says. And you didn't have a vote, you appointed somebody, and the person said that they accepted the appointment and that they were disinterested. You can't then just say withdraw. Why? Why shouldn't the person have to come in here and explain the problem? He accepted it. He's made statements under penalty of perjury. That's in this docket. Why shouldn't he have to come in and explain why he's no longer qualified? Or why shouldn't you have to file a motion to remove him, to explain everything to everyone? Because if we didn't have this hearing, there would be no explanation that anyone would understand as to why this trustee is not serving in this case, according to the United States Trustee's Office.
Lastly, we should ask some questions. Why did the trustee suddenly change with very little to no explanation? And why did the change of the trustee end up being from a law firm that has so many ties to the Chinese Communist Party? Who was behind this ominous and mysterious change? And why, at the least, can Mr. Guo challenge the materials provided by the plaintiff? Everything that I have mentioned in today's episode will be linked and are all public information. We encourage each of you to take a look and find the issues in this case for your understanding. As always, I am your host, Kelly. If you would like to hear more about the most pressing topics between the United States and China, please consider liking, subscribing on YouTube, Getter, and Rumble. Thank you for watching.